Hello everyone, welcome again to live session of Manu Law Classes. I'm Dinesh Kumar and I'm former Assistant Professor of Law at Campus Law Center Law Faculty, Delhi University, and presently I'm working as an academic head of Manu Law Classes. So dear students, in today's session I will discuss with you one of the landmark judgment of Hon'ble Supreme Court, that is Air India versus Nargesh Meerza and others. This case was decided by Hon'ble Supreme Court on 28 August 1981. Dear students, the date of CLAT examination 2022 is 8 May 2022 and the date of CLAT examination 2023 is 18 December 2022. So prepare yourself accordingly. One more information, your application window to fill the form is open on the NLU consortium and it will remain open till 31st March. So please fill your form timely to avoid unnecessary delay and wish you all the best. So now we come to the facts of this case. So basically Air India had a regulation, and the regulation number 46 and 47 of Air India Employee Service Regulation provides that a female candidate, or we can say that female cabin crew, will retire in the following three circumstances. Number one, when she will get, or when she will become 35 years of age, or she will attain 35 years of age. When she will marry. Third, upon first pregnancy. But this regulation provides the different rule regarding the male cabin crew, and it provides that the retirement age for the flight pursuers or the male cabin crew was 58. So the age of male member to retire was 58 years and the age of female member or female cabin crew was 35 years. And there were two other circumstances. One, that if she got married, she will be retired, and on her first pregnancy she will also be retired. Now the constitutional validity of these regulations was challenged before Hon'ble Supreme Court in this case, and the main issues before Hon'ble Supreme Court were that, number one, whether the regulation 46 and 47 are violative of article 14, 15, 16 of the Constitution of India and thus ultra vires in the whole or part. Secondly, whether the discretionary power as enumerated under under regulation 47 can be deemed to being excessive delegations. So basically delegation means when some power is given by one person to another person or by one authority to another authority. So in these regulation the power was given to the director, that director may take the decision regarding the retirement of particular air hostess. Now the contention of the petitioner in this case were that, number one, the retirement age of female crew member 35 is correct as per the requirement of industry because it requires young female crew members. So generally it was the contention on the part of the petitioner that in the this air industry some young female crew members are required. So as per the requirement, 35 years is the retirement age and which is suitable to the industry norms. Secondly, regulations which provide that the female crew member will retire either on being married or on first pregnancy. Such requirements are not against Article 14 of the Constitution of India because it is not against the equality, rather it is a reasonable classification considering the circumstances of the situation, and this is permissible under Article 14 of the Constitution of India itself. So the second condition was that these grounds that the female will retire on the marriage or after she will get married or on her first pregnancy these are not against Article 14, rather these are the reasonable classification which is authorized by the Article 14 of the Constitution of India itself. Now the third contention was that the power which has been given by this regulation to the director regarding the retirement age of the female crew member or the circumstances, that is the married and the first pregnancy, are not ultra vires, and these are not excessive, and these are not arbitrary in nature. So these powers are required to perform the functions properly. Now we come to the contentions of respondent. So respondent also gave various contentions. Number one, these regulations are against Article 14 because these are arbitrary in nature. So why these are arbitrary in nature? Because Article 14 of the Constitution of India provides the reasonable classification. But this classification must be based upon an intelligible differentia. It must be based upon some intelligible differentia. Means if particular authority is raising the discrimination or doing the discrimination, then the concerned authority has to provide the justification behind that discrimination. Second, it is also against Article 21 of Constitution of India because Article 21 of Constitution of India provides the right to life and personal liberty. So if we correlate these circumstances or these restrictions with respect to the right to personal liberty, so right to marriage fall under the right to personal liberty, and right to have the pregnancy is also the part of personal liberty. And these restrictions which prevent or which prohibits a female crew member to get married or to get pregnant, these are against Article 21 of Constitution of India as well. Next, the power given to director is arbitrary in nature, so it is against the Article 14 of the Constitution of India. So there is a case, that is the EP Yorappa versus State of Tamil Nadu. In this case, Honorable Supreme Court held that if a particular law or particular regulation is arbitrary in nature, then it will be deemed to be against Article 14 of the Constitution of India. So Honorable Supreme Court analyzed the contentions of both the parties and finally upheld the contentions of the respondent and held that these regulations are against Article 14 of the Constitution of India, and these also violate Article 21 of the Constitution of India of those female crew members which are the part of this Air India Industries or Air India, because it indirectly compelled them that they should not get married and they should not have baby or they should not get pregnant. So considering all these aspects, Honorable Supreme Court struck down these regulations on the ground that these are arbitrary in nature, and by virtue of EP Yorappa versus State of Tamil Nadu, if any law or regulation is against Article 14 of the Constitution of India or it is arbitrary in nature, then such regulation will be hit by the Article 14 and it will be ultra vires or null and void as per the constitutional requirement. So that's all for today, my dear students. I will come again with the next landmark judgment. Till then, thank you very much. Goodbye.